One of the most important provision of law that you should know in the Philippines, Article 125 of the revised Penal Code RPC.
In today's video, we will be learning about Article 125 of the RPC. This provision of law is helpful so that you know what you will do in case you were taken into custody. What case can you file against erring public officials or officers who violated your right?
We will also be giving the latest Philippine jurisprudence about this topic, the delay in the delivery of detained persons to proper judicial authorities.
If you like to know, watch this short video discussion and subscribe for more useful information. Comment your legal questions and we will answer.
Article 125. Delay in the delivery of detained persons to the proper judicial authorities. The penalties provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of
12 hours for crimes or offences punishable by light penalties, or their equivalent. 18 hours for crimes or offences punishable by correctional penalties, or their equivalent, and 36 hours for crimes or offences punishable by afflictive or capital penalties, or their equivalent. In every case, the person detained shall be informed of the cause of his detention and shall be allowed, upon his request, to communicate and confer at any time with his attorney or counsel.
What are the elements to be convicted of violating Article 125 of the RPC? To be convicted of the violation of Article 125, here are the elements.
1. That the offender is a public officer or employee. 2. That he has detained a person for some legal ground. 3. That he fails to deliver such person to the proper judicial authorities within a. 12 hours for crimes or offences punishable by light penalties or their equivalent. b. 18 hours for crimes or offences punishable by correctional penalties or their equivalent, or c. 36 hours for crimes or offences punishable by afflictive or capital penalties, or their equivalent.
What if the offender is a private person?
If the offender is a private person, the crime is illegal detention and not in this provision of law.
Is the arrest of the detainee legal from the beginning? When does his detention become illegal?
The detention of an arrested person in this article is legal in the beginning because the person detained was arrested under any of the circumstances where arrest without warrant is authorized by law. The detention becomes illegal after a certain period of time, because the offended party is not delivered to the proper judicial authority, within the period specified in this provision, 12 hours, 18 hours, or 36 hours.
Does this provision apply when detainee is arrested by way of a valid warrant of arrest?
This provision does not apply when the arrest is by virtue of a warrant of arrest.
What does the delivery to the judicial authority means is used in this provision of law?
The delivery to the judicial authority of a person arrested without warrant by a peace officer does not consist in a physical delivery, but in making an accusation or charge or filing of an information against the person arrested with the corresponding court or judge, whereby the latter acquires jurisdiction to issue an order of release or of commitment of the prisoner, because the arresting officer cannot transfer to the judge and the latter does not assume the physical custody of the person arrested. Sao v. Chief of Police of Manila. The term judicial authority as used in this provision means the courts of justice or judges of said courts vested with judicial power to order the temporary detention or confinement of a person charged with having committed a public offense. The judicial authorities mentioned in this article do not include prosecutors because they cannot issue a warrant of arrest or of commitment for temporary confinement of a person surrendered to legalize the detention of the person arrested without warrant. Sao v. Chief of Police.
When does the detaining officer deem to complied with the provision of Article 125?
The duty of the detaining officer is deemed complied with upon the filing of the complaint with the judicial authority.
When should the detained person be released?
Detained person should be released when the judge is not available and the maximum hours for detention provided under Article 125 of the RPC has already expired. Failure to do so will subject the officer to violate this provision of law.
Can a detention prisoner waive the provision of Article 125?
Yes, a person arrested may ask for preliminary investigation in accordance with the rule, but he must sign a waiver of the provision of the Article 125 of RPC, in the presence of his legal counsel. Notwithstanding the waiver, the detainee may apply for bail and the investigation must be terminated within 15 days from its inception. Section 7, Rule 112.
Is the violation of Article 125 a ground to dismiss the case of the accused?
A violation of Article 125 does not affect the legality of confinement under process issued by the court. The detaining officer is liable under Article 125 even if an information was later filed because a violation had already been committed before the information was filed.
Will the prosecutor be liable in Article 125 cases?
No, unless he ordered the further detention of the detainee.
What is the liability of the public officer or employee who prevents the exercise of the detainee to confer with an attorney?
Public officer or employee is liable for preventing the exercise of the right of attorney to visit and confer with person arrest at any hour of the day or, in urgent cases, of the night, shall be punished by arresto maior.
The reason for the Article 125 of RPC is to prevent any abuse resulting from confining a person without informing him of his offense and without permitting him to go on bail. Laurel v. Mesa.
I hope you learned something new today. Comment your questions and we will answer them. Source: Revised Penal Code by Luis B. Reyes.
For more useful information about the Philippine law and jurisprudence, subscribe to this channel.